maybe the best place to start is with a few statistics. So in the year to the 31st of March 2017, just in terms of stats, we looked at 57 cases through the course of the year, which is a relatively low number. It's a number that's been coming down year on year, which I guess could be indicative of a number of different things. In terms of sort of how we interpret those numbers, it could be due to macroeconomic factors, but it could also be to the way in which we've been conducting merger control in the UK over the course of the last few years. And in particular, given the UK's voluntary regime, it kind of indicates that self-assessment is working well, in that a lower number of cases would indicate that firms are really notifying to us the cases that give rise to potential competition concerns and warrant an investigation. So we are quite encouraged, I think, by the fact that number has been coming down over the course of the last few years, while remaining alert to the fact that we're not under-enforcing and that we're not missing transactions which warrant an investigation. The role of innovation in mergers. It's a hot topic. I think it's one of the hot conference topics over the course of the last year, and certainly the Dow-DuPont case from the Commission has probably received more airtime than any other merger case for a number of years. I think in some ways our perspective is that it's not a new topic. We've been considering theories of harm around innovation for quite some time. I think it's also quite helpful to distinguish what we mean by an innovation theory of harm. So we're not talking here about kind of competition between existing pipeline products or between an existing pipeline product and an actual live product on the market. So those cases have also been considered a number of times, particularly in pharmaceuticals. But really in an innovation theory of harm, we're talking about two firms which are racing together to innovate new products, often in markets that are as yet undefined. And I think the reason why this is getting so much airtime at the moment is because it's hard. It's very hard to predict the future. It's very hard to assess the various effects on efficiencies. And I think the Dow-DuPont decision has really driven that debate forward, which is why it's a hot topic. And it's something that I'm sure will develop further in the months to come. Both in the UK as much as in the Commission and elsewhere around the world. I guess multi-jurisdictional findings are always a potential challenge for the UK, given the UK is kind of the oddball in Europe with having a voluntary notification regime. So we need to remain particularly alert to the fact that we're not coming to a transaction late or later than other jurisdictions around the world. Generally, our approach is always that we talk. So we are very keen to pick up the phone or to engage with other authorities when there is a multi-jurisdictional filing, both to align on timings, which is particularly important for parties, particularly if a case goes through to remedies, but also to align in terms of our analytical approach and evidence gathering. So the competition dynamic might be very different in different markets. The competitor set may be very different, and the market may be of very different size and scale and work in a different way. But we are always very keen to ensure that we're aligned as far as possible with other authorities and really gaining as many efficiencies as we can as regulators from other authorities in the way they're doing things. So currently, we pick up the phone particularly a lot to the States. Post-Brexit, we can expect that to happen far more with the Commission. Well, it depends what your starting assumptions are. I think if we start from an assumption that we're going to be outside of the one-stop shop, we can certainly predict that we're going to be a lot busier. We've run some numbers and we're expecting between 30 to 50 additional cases in the UK post-Brexit, run in parallel with the Commission. Of those, it's hard to tell, but we would estimate roughly 6 or so of those cases going through to phase 2. But I think the other thing is that it's also a challenge for us in terms of the mix of cases, because some of the cases that the Commission looks at the moment are much more business-to-business markets. They're often much larger transactions, global transactions. And so it would change not just the volume of cases that we're looking at in the UK, but also potentially the profile, the portfolio of a mix of cases that we're looking at. And one of the challenges isn't just that we'll be liaising with the Commission on those transactions, but because they're much more often global transactions, we would expect to be coordinating more often with other authorities around the world. Much more than we do so at the moment. But those are fun challenges that we're up for, and it's certainly the CMA is certainly an exciting place to work over the course of the next couple of years to see this through. Well, I guess the good thing about this conference is it covers kind of all areas of competition law, and I think you get a particularly good insight into some of the Commission's work over the course of the last year. So it's a good retrospective in that I think there's quite a thorough review of Commission cases across all areas of competition law over the course of the last year. while also giving you a few kind of thoughts from key practitioners about where trends might be going in the future. But I think it's that kind of fairly comprehensive retrospective that makes it a useful conference for practitioners.